Good afternoon, everyone. Thank you. Thank you for doing that back. It's so good to be here on a beautiful October afternoon and to see so many wonderful faces. As I look around the room, I see a lot of people who have joined us here in the sanctuary before for many of our presentations, and we welcome you back. And if you are a newcomer to the Rothermel Foundation presentations, we welcome you especially. Anyone here for the first time? Raise your hand. Good. Then I would like to say that after today, I have a feeling it won't be your last time. So please do come back and join us. I'm Linda Staunch, and I'm a member of the Rothermel Foundation Board. We have many wonderful board members here. I wish you would raise your hand if you're here, because you might be called upon to do something or say something for someone, and we want you to know who we are. We're also listed in the program. But again, welcome. It is so nice to know that you take time out of your beautiful, busy day to come and be intellectually stimulated among friends. So we like that. This is one of usually several programs that we put on during the year, usually right here in this sanctuary. Typically they are fall and spring, and we try really hard to come up with topics and with speakers that you think will be provocative and thought-provoking as well. We've gotten some things on our board. If you had a chance to look up there before we started, I'll give you just a brief idea of the format. We have a presentation by a speaker. There will be a 10-minute intermission, after which we invite you to come back for question and answer. I would suggest to you that even though the time grows longer, that sometimes that's one of the more provocative parts of the programming, because you have real questions of your own presented to the speakers for their discussion. Please note, with your program today, we have a card, which we always do, and the card gives you a chance to put your email address on the back so that we can continue to inform you about our presentations. It also has a place for you to suggest topics of interest to you that we can consider for future programming. At the end of the programming, we will remind you the bathrooms are in this building right behind the sanctuary. You'll find them pretty well marked. When we go for the 10-minute break, there will be cookies and water and punch right over in this building here. And then after you do that, you will come back and join us here. So again, thank you very much. We hope that you will enjoy the presentation. And right now, it gives me great privilege to ask Lily Stern, who's a member of our foundation board, to come up and introduce our speaker. Lily?
Ladies and gentlemen, it is an honor and a pleasure to introduce a fellow member of Temple B'nai Sholem, which is right over here on Middle Street. It's also a pleasure to see so many of our fellow congregation members here today with us. And also, Michael is a dear friend of my family. I will tell you that I had the joy of meeting his wife, Jane, first, several years ago when she came to our house as a hospice volunteer. And she played some very beautiful, soul-moving Native American flute music for my father during the last months of his life. And Jane is a true gem. So the first thing that I can tell you about Michael Tigar that you may not already know or have seen on the slideshow is that he has impeccable taste. You already know that Michael is a legend in legal and human rights circles. You probably know that he represented the likes of Angela Davis and Terry Nichols. His bio speaks for itself, and many of you, I'm sure, have read it. So I won't take time to review that. I did, however, read a piece that was written up about Michael in the Washington Post back in 1997, and there is one paragraph that I thought was really beautiful, and I would like to share that with you. So it says, "Indeed, at times, Tigar's raw knowledge seems intimidating. He is a gourmet cook who fluently quotes 18th century poetry and the Bible, has published books, plays, and scores of articles. Teaches law classes in France in French. And routinely causes his colleagues to squirm in court with citations of obscure case law. When he received a prestigious Human Rights Award for his 15 years of work on a case of a former Chilean Marxist official and his aide who were killed in a 1977 Washington car bombing, Tigar delivered the acceptance speech in Spanish, in a Chilean dialect. A few more things that you probably don't know about Michael. This actually reminds me a bit of The Sound of Music. After the family Von Trapp made their final performance, they escaped off into the mountains. Well, Michael, immediately after his lecture today, is escaping on his beautiful trawler named Tara with a very good buddy of his from our temple. I won't name him, but he's seated somewhere up there. And they're going to be moving Tara to warmer waters down in Charleston. Later they will be joined by his wife Jane. And I can also tell you, because I had the privilege of being the caretaker for the Tigars' household of animals, that this morning, like every morning, Michael rose up before dawn to clean the roost of their 8 lovely chickens, some of whom are named Lady Gaga, Simona, Yentl, and Rosalind. And there are 4 others that I have not met yet, but I'm looking forward to meeting. And they have 3 beautiful feline boys, Gomez, Cezanne, and Caravaggio. And last but not least, a 40-year-old parrot named Flo who sings opera. I share this with you because the Tigar household is exceptional in every way. Truly. Michael and his wife Jane are a gift to humanity, and I assure you that you are in for a treat today. Hopefully he will be giving his remarks in English, maybe with a little bit of a California accent. Without further ado, I'd like to introduce you to Michael Tigar.
So 50 minutes of disappointment. I do want to thank you for inviting me to spend this time with you. This room should remind us all of many things, religious and spiritual sentiment to be sure, but also the role of moral sentiment in shaping our social condition. The topic on which I'm going to speak today has occupied me. We're flipping through here. I think we're going to get it right. You can ignore that if it's distracting. For more than 50 years. When I was in high school, Arthur Kester had published a book called Reflections on Hanging. And I bought it at the age of 15 and read it. And it struck me that this was an issue that was worthy of concern. And I spent my summer then reading about cases of this kind. And so we have it, the debate in context. Now, everybody here has an opinion about the death penalty. As a juror, you would be asked to vote in a particular case. Experience teaches us that your opinion is going to, are we all right here? Yes, we're good chance. All right, that your opinion may differ, your answer may differ, based on how the question is put. That is to say, if I ask you, do you think there should be a death penalty? Maybe most of the people in the room would say, well, yes. And then if I were to ask the next question, do you trust the government to get it right? The answer would be no. And that would help to frame the discussion. We are all shocked by news of terrible crimes that are committed in our community and in communities around the world. We ask ourselves how we would, if confronted with the decision, make that decision. Because we can't have a death penalty one case at a time. If we're going to have a death penalty, we must have a system by which it is administered. And without suggesting how you ought to think about that or what you ought to think about that, that's where I want to focus today. Reasoned moral response. The title of the lecture is Reasoned Morality in the Death Penalty, and I borrowed that from Justice Sandra Day O'Connor's remarks in California versus Brown. That is, the sentence imposed at the penalty phase should reflect a reasoned moral response to the defendant's background, character, and crime. That has become the Supreme Court's iconic words in talking about what we ought to do about the death penalty. I regret that Sandra Day O'Connor left the court when she did. She stood at the center. She stood as a reasoned voice. And I'll tell you something, if you ever argued up there and you heard that question in your unmistakable voice, that was 5 votes, so depending on the answer that you were about to give. So today I want to share some information about the history of capital punishment in the United States and to some extent elsewhere. What you think about it, well, that's up to you. By way of introduction, beyond the animals that we have in the front yard and in our living room, I have dealt in the defense of those accused of murder. I have assisted, along with Jane, in the prosecution of those accused of murder. This is a talk not about opinion, but what we can know and verify. A brief history. We know from the Old Testament the kinds of punishments that were meted out, and I probably will get a question about chapters 21 and 22 of Exodus before the day is over. In this building, of course, we think of crucifixion, but nearly 100 years before Christ was born, Marcus Tullius Cicero, a great Roman orator, called crucifixion a most cruel and disgusting punishment. In the Eastern Roman Empire, when the Emperor Constantine converted to Christianity, he abolished it as a punishment throughout the Eastern Empire. The method of execution would vary over time in many cultures. But that's the history that really doesn't touch what goes on today. Our current history of capital punishment begins with something called the Black Act. In the early part of the 1700s, English society was faced with 2 problems, or at least the majority of the Parliament thought they were. The first was that there were peasants who persisted in holding on to their centuries-old rights, as they called them, to hunt in the forests, to gather fallen wood, and in short, to live their lives. The encroachment of enclosures and the demands of property owners who wanted to do something else with the land needed, the Parliament thought, to be enforced. And so draconian measures were called for. Now the second problem was that at the same time, where did the peasants go? They went into the cities. Where living in conditions of poverty, all sorts of petty crime was committed in the streets. And so the Black Acts of 1720 and 21 created more than 100 offenses that could call for the death penalty, including going disguised in the wood, hunting rabbits, stealing without violence of an amount more than 2 pounds, that is 40 shillings, begging in the street without a permit, and so on. And that was the situation throughout the 1700s until the Reform movement began. 2 currents of opinion began to appear to change this situation and to frame the debate, as Arthur Koestler's book eloquently says. And by the way, there's some yellow sheets outside that have some of these sources that I'm citing that you can look up, take home, Google references, and so on. 2 currents of opinion. First, Sir Samuel Romilly, whose name will forever be associated with the movement to limit or even abolish the death penalty, began to introduce legislation in Parliament as early as the early 1800s, finally succeeding by about 1820. But what also happened was that jurors would look at these defendants, these hapless creatures, and say to themselves, how could this be? And so there is this one case, well known, in which a fellow had stolen a 10-pound note out of somebody's pocket, and the jurors found the 10-pound note was worth exactly £1.19. That is to say, a shilling short of 2 pounds, so that it was not a capital case. And we have to remember that although our founding fathers, although the framers of our Constitution believed that the right to counsel was so important, they wrote it into the 6th Amendment. In the United Kingdom, in England, you didn't have the right to counsel in cases of felony and treason until 1802. Throughout the majority of this period, these folks were hauled in off the street and tried by jury without the benefit of counsel. Now, coming to the United States, you'd expect the Quakers to do something about this, and they did. They took a leaf from chapter 21 of Exodus, and they divided homicide into two parts, first-degree murder and other crimes of murder. First-degree murder, our common notion of premeditation, deliberation, and lying in wait, that could carry the death penalty, whereas other kinds of murder could not. Sort of a compromise that dominant Quaker forces insisted upon. But in almost every American state, and in the federal courts, the rule is this: if the prosecutor decides to seek the death penalty, the jurors would be asked to find guilt or innocence, and then in their unfettered discretion to say whether or not there should be mercy. So what we had was a situation where elected local public officials, prosecutors, chose who would not be subject to the death penalty. The term is going to use one way that you'll be hearing called death eligible. Of course, you know, we all are. But that's another one of these things that lawyers have imposed upon the language. And if I slip into it, please forgive me. I don't mean to be silly. And then the jurors, in their unfettered discretion, could decide whether to give mercy or not. And who were these jurors? They were white men of property. And I needn't tell you, anecdote by anecdote, we'd be here for a week, how those cases tended to turn out, and where the jurors might or might not decide to exercise this power of mercy. Because one of the themes about which we're talking today is the fact that in order to vote to take somebody's life, you really have to believe in some way or other that they are the other. That they have somehow forfeited their right to live on the earth. And how much easier is it to do that for someone who is very different from yourself? For ye were strangers indeed. Anyway, most U.S. states had this list of capital offenses. It included murder, rape, and so forth and so on. Well, the world began to change. In England, in 1965, the death penalty was abolished. In France, it was abolished in 1981. An interesting thing if you're going to study this. When Mitterrand became president, François Mitterrand, Robert Badinter, who had been a member of the French resistance, a prominent Jewish lawyer and scholar, went to Mitterrand and said, I have a number of things I want to do. One of the things is to reform the French penal code, which he did. The other, Mr. President, is I want to abolish the death penalty. Mitterrand said, well, if you can get it through the Chamber of Deputies and the Senate, then good luck to you. Well, they did. And today in France, after that tumultuous time, you wouldn't get 10% of the votes to reinstate the death penalty. Once the decision was over, it was over. I lectured in Aix-en-Provence to the new generation of students who grew up in a country without the death penalty, and about, you know, les autres du monde de la capitale s'organisent what? You do that? You do it this way? How can anybody? Anyway. South Africa in 1995 abolished the death penalty. It did so in the very first case considered by the Constitutional Court, a court that was created to interpret the new Constitution and its Bill of Rights, all of whose members were appointed by Nelson Mandela. And as the court was sworn in, Mandela remarked that he looked around the courtroom and said, you know, the last time I was in this courtroom was to find out whether I was going to get the death penalty or not. And as Justice Goldstone said, I think he was trying to influence us. And they voted unanimously. Today, the European Convention on Human Rights, by its 13th protocol, abolishes the death penalty throughout the European Union. 137 countries have abolished the death penalty, and there's an international movement similar to that that took place in the 19th century with respect to slavery. Well, the debate reached these shores. In 1972, the Supreme Court decided a case called Furman versus Georgia. The system is broken, the court said. This unfettered discretion reposed in prosecutors, uncorrected by the unfettered discretion reposed in juries, simply doesn't work. It's cruel and unusual, and it lacks due process. And so all of the death penalty statutes in the United States, and the 37 states and the federal government that had it, were really invalid. Well, the drafters went to work. They came back to the court in 1976 in Gregg versus Georgia. And most of those newly drawn statutes were approved by the Supreme Court. This goal of narrowing the world of death eligible people, and of rationalizing the process by which the death penalty was sought and administered. The watchwords of the new constitutional doctrine, in the words of Justices Stewart, Powell, and Stevens, were, we are trying to get at this risk of wholly arbitrary and capricious action. Well, in the succeeding years, the court has confronted this issue dozens of times. It does so in the name of cruel and unusual punishment. It guides prosecutorial discretion and seeks to eliminate racial bias in the selection of defendants. It deals with issues of minors, young people, that is to say, no death penalty for crimes committed before the age of 18, no death penalty for the severely mentally retarded. Even for those not severely mentally retarded, the jury must be instructed that this is indeed a mitigating circumstance the jurors must consider. Even when one is over 18, up into the 20s, the jury must be instructed that youth is a mitigating factor. You can see why you need an instruction that it is, right? Because it's double. As the twig is bent, so grows the tree. This is a deliberate decision to say, no, 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 you have to take it for its mitigating weight. You, the jurors, are forbidden. It notes the idea that this is a person who is more likely, because young, to kill again. And then methods of execution. You've all read the controversy over methods of execution. You don't need to spend a lot of time on it. But surely that controversy has gone on and will continue as pharmaceutical companies refuse to provide the chemicals necessary to cause death, while states struggle to find alternatives, and those are in turn subject to challenge. Death-eligible crimes. That is to say, today, as Justice Kennedy said, the death penalty is regarded as a constitutional matter that is appropriate only when human life is taken. Not only that, the defendant must have materially participated in the crime, not simply as an onlooker, as the driver of the car, whatever, but in some material way. Young offenders, I've mentioned. Jury consideration is guided by these instructions about all these mitigating factors. Of course, now the court recognized in capital cases, as it had for years, this right to counsel. And in most states, and now by federal legislation in all states and in the federal courts, there is some minimum guarantee that lawyers appointed to represent people in capital cases are qualified in the sense that they have relevant experience. In addition to that, the Supreme Court has held that there is a right to defense services. Let's spend a minute with that. Everybody here has read about DNA testing and crime scene and forensic evidence and so on. What you need to do, if you're representing someone in a capital case, is to grade the paper of the people that investigated the case. You need the right to do independent DNA testing. You need the right to figure out why it is and how it is that the crime scene evidence was conducted. You need to figure out what influences were brought to bear on people who say that they witnessed the events, because eyewitness testimony is notoriously subject to influence, and so on. In addition to that, after Greg, we have the right to present the mitigating evidence, the result of our researches, and to have it considered. So present it, have it considered. We have the right to representing death in capital cases, not just to have it, but to have the judge tell the jurors what they have to do with it. And the Supreme Court, in a case called Morgan versus Illinois, held that unless a juror is willing to say on his or her oath that they're willing to consider the judge's instructions and abide by them as to the mitigating effect of the given evidence, then they're not eligible to serve. Then there's limits on aggravating evidence. That is to say, evidence in aggravation of these terrible crimes can tend to cause jurors to value the evidence, to pick up on the anger and vengeance. And so the court has been careful to address those kinds of issues, to make sure that prosecutors in summation don't sneak in racial bias in cases where they think it appropriate, and so on. In addition, there's this layer of appellate review. If you're sentenced to death, you have the right to go, after your case is appealed, to go back to state court for habeas corpus consideration, and then move into federal court for further consideration. That's the part of why this process gets so lengthy. However, it's common to the capital jury. You're not eligible to citizen juror in a capital case unless you're willing to impose a death penalty. That is a major source of controversy. Had Dzhokhar Tsarnaev been tried in Massachusetts State Court, he could not have faced the death penalty because the people of Massachusetts said they didn't want it. The federal government says, no, we're the federal court, supremacy clause, we're seeking the death penalty. And thus you have this business in a capital case of the death qualified jury. That is to say, the prosecutors are out there making sure that jurors are willing to vote for the death penalty when the time comes. I was talking to Father Tully about this. We get in the Nichols case, we had several Roman Catholic jurors who quickly said, look, I'm Roman Catholic, I can't vote for the death penalty. Well, then that required counsel to spend a half an hour discussing with them possible cases in which they might want to take a human life, so they wouldn't be disqualified from the jury, and the government have to use the correct examples to get rid of them. I apologize to the church for trying to persuade the faithful that they might, consistent with their conscience, take a human life. It was all in the cause of representing the defendant. So, the next slide. What could possibly go wrong? With all of these protections, what could possibly go wrong? We have 155 exonerations as of June 2015 in capital cases. By those I mean months in which it is beyond dispute that they got the wrong person. More than 200 exonerations in serious non-capital cases. The Brooklyn District Attorney had 31 questionable cases under review and found that 11 of them needed the verdict to be set aside. Of 20 capital case exonerations based upon DNA evidence, 10 defendants have falsely confessed. They've been worked over in the police station and confessed to crimes they did not commit. Why do we put in there Harry Connick? Harry Connick Jr. is a musician. His dad is the district attorney of Orleans Parish. And I know Harry Connick Sr. and I like Harry Connick Sr. But I'm happy to tell you that in 3 cases that made the front page, Harry Connick Sr.'s office withheld from the defense evidence that showed that people that got convicted and got the death penalty didn't do it. And one of them made it to the Supreme Court, the case of Kiles versus Whitley, which you can look it up on Google. Here's Mr. Kiles, an elderly woman is killed. Connick's office has an informant named Peanut. And Peanut, who they know is unreliable, gives up Mr. Kiles in exchange for other favors and so forth and so on, sets the cops on the track, and lo and behold, one thing leads to another, and by golly, not until it gets to the Supreme Court, but 5 before the court reverses the conviction, sends it back to a new trial. What is it that moves folks to behave in this way? In Orange County, California, the district attorney's office and the sheriff's office was found to be planting informers in the jail were next to capital defendants so that they could claim to have had conversations in which people inculpated themselves. That's going to require the re-examination of some 150 or 200 convictions that took place in Orange County, California, among them capital cases. Well, here's the problem. A murder disturbs the community. These crimes are terrible crimes. And the community wants reassurance, does it not? And the police are in the business of giving them, the community, that reassurance. That's one of the reasons to do it. And the trouble then is that the very severity of the crime gives kind of a seeming permission to police and prosecutors to ignore the traditional safeguards in the interest of getting to a result. Also, it's, G.K. Chesterton said of the English judges, they're not cruel, they just get used to things. And that kind of studied indifference can often be cruel or can it not, and deliberate vengeance. And so why? The law is not what it says, but what it does. I have told you what the law says. But we all in our lives know the ways in which what ought to happen doesn't quite. After all, the Supreme Court hears 70 cases a year. It is distant. It is divided. Ever since the Miranda decision that everybody knows, there have been prosecutor workshops telling you how to get around it and make the arguments and so forth and so on. It's kind of organized hostility to behaving in this way that the Constitution requires. These are terrible crimes. Community wants answers. And when petitions are filed for suicide convictions, people, they get disturbed. I mean, well, surely he did it. I mean, after all, it was a terrible crime and so forth and so on. These human motivations are powerful. Human error is possible. Now let me think about, let's talk about that for a minute. We all think of eyewitness testimony as being an important and presumptively reliable thing, or maybe we don't. But given now all of the evidence in which it turns out to have been wrong. You see, particularly when you see an event quickly, and it's disturbing, and maybe it's people with different race that are doing this and that, eyewitness testimony turns out to be unreliable at the outset. We do not see things as they are, and ISN says we see them as we are. We see what we want to see. And those who think that because an ISN won't come up with it, we should talk about it, we can talk about what's all South. South, in Being and Nothing That's Right, a chapter. At the beginning he says, I'm scheduled to meet my friend Pierre at a cafe. And I am late, and Pierre is always punctual. I go to the cafe is filled with being. Plates, cups, sausage, noise, people, so forth and so on. And were you to ask me later, what did you see in the cafe? I would say to you, well, I'll tell you one thing, Pierre wasn't there. And Sartre says in his notable line, he said, it all depends on the direction of my attention. The most important question is not, what did you see? The first question has to be, what were you doing there? And so, this is human error. This is honest human error. Plus the fact that witnesses then, who have had these experiences, get into the hands of prosecutors and police, who prepare them to testify, thus in some measure divorcing them from the human experience that they are attempting to recapture. Errors and omissions in forensic science. The majority of state laboratories, crime laboratories in the United States, are not certified by the certification agency. For years, the FBI lab was not certified. The FBI laboratory at the time of the Oklahoma City bombing case was being operated by people who did not have degrees in chemistry. They had a PhD who was working there, but they fired him, and he was engaged in a lawsuit. And to prove how incompetent the lab was, with respect to World Trade Center 1, not the airplanes, but the other bomb that was in the basement, he rushed into his superior's office and said, I found out that the basis for this bomb was uric acid. You can build a bomb using uric acid. And the guy said, oh my goodness, here it is. And he let him go on for a day before I corrected him. What he had done was urinate in the glass and evaporate it off and take it in. And the head of the FBI was completely fooled by this. He thought that he really was on something. Yes. So errors in DNA, errors in forensic science these days, these things happen. And what else? The prosecution or defense of a capital case is challenging, and it's emotional. From the beginning to the end. It is one of the things that in representation of someone accused of a capital crime, you have to begin by addressing. And in the Nichols case, if you look up the opening statement online, I started by saying that at 9:02 in the morning on the 19th morning of April, Jimmy McVeigh parked a truck while they were set off the bomb. 168 people died. Thousands, hundreds more already, tens of thousands, millions of dollars of property. And we stipulate and agree and confess that that happened. Now, it may be members of the jury that the government's not going to accept that. But they're going to insist on playing for you video tapes that you've already seen, and audio tapes of people's anguish that you have already heard. Also, we should be angry enough to say somebody must be punished for this. But we understand that the world has no such joy to give as that which it takes away. And we will be here to question all of the witnesses who come. Because the question is not, did that happen, but can the government prove beyond a reasonable doubt that Terry Nichols had anything to do with it? And we don't apologize for the questioning that we're going to do with those who lost so much. Voltaire said, it is for the living we owe respect, the dead we owe only the truth. So, then there's the victim organization. Not in every case. The prosecution is entitled to present victim impact evidence. That is to say, the feelings that people have about the loss of their loved ones. And in the Oklahoma City case, Congress abolished the restriction on people being able to both testify and sit in the audience. Half the seats in the courtroom were occupied by victims and families. The rest, there was a video feed to Oklahoma City that all could watch. And there was a sense in which a majority, but not all, of the victims thought that getting a death penalty in the McVeigh and Nichols cases would bring them closure. This is a word we hear so often that you'll have to evaluate for yourself. My own experience has been that people go to these executions and they see it happen, and then afterwards they say to themselves, you know, I didn't get the comfort out of that that I thought I would. There's this feeling, as I say, of vengeance and anger. And it's very easy for the jurors to get caught up in it. I'll come back to that. Some people just don't do their jobs. Clarence Wiggins was charged with a capital crime. There was relevant evidence to be found that might have exonerated him in his medical history, educational history, employment and training history, family and social history, prior adult and juvenile correctional experience, religious and cultural influences, all of that. And his court-appointed defense counsel didn't look up any of it. Presented almost nothing. Opposed mitigation of the death sentence that was being sought for Mr. Williams. And he was sentenced to death. The Supreme Court of the United States reversed, saying he had ineffective assistance to counsel. This is sort of two-sided thing. I'm been appointed by the court to represent someone in the capital case. Jane was on that team. We had our team of lawyers. I got up every morning and worked. What if I did something wrong? What if I didn't do my job? What if innocently I made some mistake or let something go? To whom would I apologize when all this was over? Mr. Williams' lawyer didn't see it. Worst example is Mr. Corey Maples. Mr. Corey Maples was sentenced to death in Alabama. His case was affirmed on direct appeal. Then he had the right to file a state court habeas corpus action. Two lawyers from the New York law firm of Sullivan and Cromwell, a very well-known white shoe law firm, agreed to help him. They got together a brief, which with the aid of the local Alabama lawyer, we said, look, all I'll do is sign your papers so you can file it down here. They filed a brief. And while the case was pending in the Alabama State Trial Court, each of them got new jobs. And they left the firm without leaving a forwarding address. The court, Alabama State judge denied relief. The order came into the Sullivan Cromwell mailroom, where it was duly returned to sender, undeliverable. And of course, Mr. Maples then got him to appeal his state court habeas. Well, then new counsel came and filed in federal court. Federal court said, hey, I'm sorry, you have to have exhausted your state remedy before you come in. Well, the Supreme Court finally decided that if your lawyer abandons you, then the fact that you missed a date somewhere down in the process could certainly be excused. But this good day, these lawyers have not apologized. They've been very defensive about it, despite a number of articles that have been written. And that's only one of the more egregious cases. But as I say, sometimes people just don't do their jobs. The atmosphere of decision. In the Oklahoma City case, this is one example. acquitted of first-degree murder of the 8 federal agents, acquitted of second-degree murder of the 8 federal agents, convicted of involuntary manslaughter of the federal agents, and then convicted of conspiracy, which did not include death as a crime. Judge Bates decided that nonetheless he was death eligible and he would have a penalty trial. The families, those federal employees who were killed, who lost so much, were so angry that the jury had not come through and convicted Terry Nichols of first-degree murder, that they and a number of the victims held public meetings to express their outrage during the time that was between the original verdict, the validity phase, and the beginning of the penalty phase. That gap took place over the first-time holiday, December into January. That emotional outbreak, that emotional content, then spilled over into the penalty trial. As one after another, those who had lost loved ones took the stand and cried, as of course they would, but then expressed their anger at what the jurors had done. The atmosphere was so hostile in that courtroom that the foreperson of the jury sat most of the time like this, in a posture of meditation, to try to maintain her calm and dignity so that she could lead the deliberations. Again, you can't vote for death unless you believe that this person is the other. And therefore, one of the tactics of prosecutors and of some in the media from the very get-go is to demonize the defendant, to make the defendant into the other. Indeed, in the Oklahoma City case, so great was the desire to find a demon that a Jordanian was arrested at the Oklahoma City airport because, after all, it must have been the Arab terrorists that did it. That's what happens in these cases. And so you ask yourself, well, how can a judgment about justice take place? How do we help the jurors see this defendant as a human being? One of the most poignant examples of that I know of is my daughter is a physician. She specializes in addiction medicine. She's on the faculty of Baylor. She testifies in the mitigation phase of capital cases of the defense. For example, beginning by saying this young man was given cocaine by his caregivers at the age of 10. Let me show you some pictures of what happens to the part of the brain that has to do with making rational and sensible decisions. And interestingly enough, I don't mean to be pessimistic about this, jurors listen to that. It all has to do with the quality of the presentation, the importance of counsel, bringing to bear some rational discourse. And even in Harris County, Texas, jurors are willing to listen. So, where does this leave us? You know, before the Senate now, there's a bill, Congress, to greatly reduce the amount of people in custody in federal prisons. We are the incarceration nation. We have 5 to 7 times the rate of incarceration of any comparable country in the world. And 5 to 7 times. Until the Supreme Court began to look into it, we had more than 2,500 people serving life without parole for crimes committed before they were 18. We were the first in the country in the world. Israel was second, they had 7. And so this talk today is a part of a broader set of issues that the community, it seems to me, needs to address. So, where do you stand? Now, that's an interesting idea. In what spirit will you stop? You know, when the case was brought in Oklahoma City, Governor Keating said, we'll give these boys a fair trial before we execute them. And we were grateful for that. being affected by it. And he called, and I'm not being unfair to Wayne Alley. This is, he would say, Miss Wayne Alley, the documents come out to me. I just want to let you know I denied your motion to recuse me. I said, well, Judge, I have not made a motion to recuse you. He said, you will. And I was trying to save time. Well, the 10th Circuit held, no indeed, none of the Oklahoma City judges could sit. And so Judge Page came from Denver. You hear a motion for change of venue, which the government resisted. With witness after witness, they resisted. They wanted this case tried in Oklahoma City. And this is what I said to Judge Page. Two roads diverge before us, gathered as we are, with the decades of constitutional liberty piled so high. The anguish of victims close at hand. In one of these roads we are beckoned from sadness to anger to vengeance. Governor Keating beckons us along that road by what I suggest is a deliberate design. The media have beckoned us along that road simply by their desire to serve their market. The other road I suggest to the court is the one the framers laid out for us, while the memory of unfair trials and distant forums was fresh in their minds. We neither dishonor nor deny the grief and anger of the victims, or even their cry for vengeance. Your Honor, this is my 30th year in the law, and I believe more than ever that when we summon someone, anyone, Terry Nichols, to court to find out whether he's going to live or die, it is our job to construct where we best can a kind of sanctuary for the jungle. A place of decision. Now, we tried the Nichols case. We had this anger all around us. I tell you that the anger was so palpable that there were threats made on our defense team by people who thought they were seeking justice for death. And so my mother and my daughter in Denver for the holiday did their shopping at the Cherry Creek Mall with a nice lady marshal walking behind them with a big gun in her purse. So when the penalty phase began, I stood up and talked to the jurors in opening statement. And I said that I was not going to raise my voice above the voice I'm using right now. Because it seemed to me that this was a kind of a decision that could not be made if people started yelling. When you think back and tell yourself, there's some really good decisions I ever made with anger. You can surely think of ones you made that weren't so good. And so at the end, in the closing argument, I said this. I feel now, when I think about that evidence, referring to the victims, as though I'm standing before you and trying to sweep back a tide of anger and grief and vengeance. And I'm given pause by the fact that I feel that way, and I wonder sometimes if I do feel that way. But when I think that, then I think also of the instructions that the judge is going to give you. Because those instructions, as we contemplate this tide of anger and grief and vengeance, can get us all to higher ground. I am, when I say this, not attacking these victims. We know their sacrifice, but we know that with the centuries of our civilization piled so high, we have come a very long way from justice based on vengeance and blood. Now the image I around was one that I remembered, I thought, because my daughter lectures people who are addicted to substances. And she uses the metaphor of your addiction. She said, your addiction is like a tsunami. She said, you're not putting on water wings is not going to get you there. You have to get off the beach. Well, and so I used it. But then later on, and I just smiled maybe around the room, I thought, higher ground, now where did I hear that before? That phrase, it came from the hymn I heard as a child. Lord, lift me up and let me stand by faith on heaven's table. Higher flame than I have found. Lord, plant my feet in higher ground. With the descent of public discourse into anger on this issue and so many others, it seems to me that higher ground is a good place to stand. What do we think about this?
Well, I think we're all riveted to our seats. But while we are that way, why don't I suggest that we get up quietly, go and have some refreshments, some gluten-free refreshments if you prefer, some calming down, and come back with your questions. Our Rothermel board members with the lapel pin will take up your questions and we'll come back and address them here in about 10 minutes. We'll see you then. Okay, a couple of things I wanted to mention, and thank you all, so many of you all, for coming back. As you know, this is another good part of the program. I believe we have some of Michael Tigar's books over in the other building for sale if anyone is interested. Thank you. We still have a few left. Also, an acknowledgement. We understand that it was difficult for some of you all to hear. We apologize for that. We don't always know that ahead of time. Michael had a lavalier mic that he had cut on, and we thought that it was covering everyone, so we're going to make sure that you can hear all the Q&A, and so I'm going to share this mic that I think you can hear with him for his responses. Can you hear this okay? Yeah. Okay, thank you. And thank you. Thank you again, Michael Tigar. Give him another hand. Okay. Bear with me. I have your questions, and while everyone writes impeccably, occasionally my eyes don't read without fault. So if I stumble over a word or two, just bear me through, and we'll get to the answer. Okay, let's begin. The first question is, it has been asserted in the past that it cost more to execute a murderer than to keep him locked up for the rest of his life. I don't know if this is generally true, but if it were true, does such an economic argument have a proper place in the construction of a reasoned argument for or against the death penalty? And part two to that would be, should the economic argument be rejected as inappropriate for seeking higher ground for the debate? Mr. Tigar.
The answer is yes. If a death penalty case with appointed counsel and the layers of appellate review, and if counsel's doing their job and asking for defense services, in the Nichols-McVeigh case, the requests for compensation, defense counsel, and services are of course confidential and remain so. But you're talking on the order of several millions of dollars on the defense side, and about twice that on the government side. So you can do the arithmetic. Whether that's a legitimate consideration or not, I can't answer that. I mean, obviously, we ought to be thinking about the costs of whatever system we're using to identify and try and punish and rehabilitate people. For me, the order of magnitude of the economic issues here would not say that is a relevant factor, but I've talked to an awful lot of people for whom it is.
I'm going to suggest that we trade places. You are the focal point, not me, so I'm going to go behind you if I may.
Okay, sure. Here, tell me where to be.
I want you right up front, son. Right over there.
I am told that there's a video recording of this thing, and that somehow arrangements will be made if people want to get access to it at some future time. Watch the Rothermel website, and I'll try to keep track of it too. I'm sure the NSA's recorded it, but we don't know.
Thank you for that clarification. Mr. Tigar, you asked, where do you stand? What about those who seek justice in the use of execution and not retribution?
Well, what about those who seek justice in execution? First, I think that those who say that watching the execution or having it happen brings a sense of closure or fulfillment. There's been a great deal of writing about that. Jody Madera at Indiana University has written a book called Killing McVeigh that I reviewed in the Michigan Law Review. The evidence that folks find what they're looking for is pretty thin on the ground. And so I guess that's something that one would have to consider. You know, how many times in our lives have we said, you know, I thought I wanted that. And that's something that has happened in so many of these victims' organizations. I can't answer the question for you personally, obviously. That's one that everybody has to answer. But this is what's happened to people who've gone before.
Thank you. Is it ethical for a lawyer to defend a person he knows to be guilty?
It's not only ethical, it's required. That is to say, if I'm appointed by the court to represent somebody, then that's my job. And what is my job? The job is not to absolve anybody, it's to make sure that the government can't put anybody in prison or execute them without a trial in which the government gets reliable evidence that convinces a jury beyond a reasonable doubt that the government plays fair, that it abides by the rules set out in the Constitution. That's a decision that the framers of the Constitution made, that every once in a while some so-called guilty person is going to get loose. And then the next question is, you know, people ask this question as though guilt, innocence was the end of the inquiry. It's not. The question is, what should we do with someone who has torn the social fabric? I have represented people who have committed crimes. And often, you know, 90% of the criminal cases in the United States are resolved on guilty pleas. Our job is to try to get effective counsel to negotiate those guilty pleas and make sure the case gets investigated. So the fact of the matter is that most people who are, you know, dead to rights, they got it. Then the job of the lawyer is to negotiate some solution to the issue that allows for rehabilitation, allows for retribution, allows for reintegration of people into the community, and so on. So to some extent, the question is, is a little bit misplaced. Again, there's a book called How Can You Represent Those People? Edited by Monroe Friedman and Abby Smith. You can get it on Kindle. I have one of the essays in it, but I'm not getting any royalties from it, so there's no shameless comment. That answers the questions from a number of different perspectives.
Is there more support for the death penalty in the South? And, given the repeal of the death penalty in Europe, is the death penalty even justified in the U.S.?
Could I read that whole question? That's it. Yes, it is. Yes, in the southern states have held on to the death penalty for longer, and you find a great many more capital prosecutions being brought in southern states than in other parts of the United States, even those states that have the death penalty. There are counties in Alabama where you get one a week. So can the repeal in Europe ever justified in the U.S.? Yeah, you know, there's a big debate going on in the Supreme Court of the United States right now whether the worldwide abolition movement should have any influence on what the United States does. And Judge Posner, conservative judge, would say, you know, we have our own law. We don't need to listen to these foreigners and all their ideas about these things. Well, you know, the interesting thing is that in the first 100 years of American independence, the Supreme Court of the United States cited Vattel's leading treatise on international law more than 100 times. That is to say, this infant nation realized that if we were to join the family of nations, we'd have to be listening to what other people were doing, and that we might even learn something.